All right, welcome everybody. Today's topic is rules of engagement. We have quite a big crowd, and it looks like we've just kind of got a lot of different roles joining today. So we are with the partners of Mendel Owens, Tom and Fraser. Say hi.
Hello, folks.
Everyone.
So we wanted today's topic to have a unique footprint, something that SCA hasn't done, but I haven't seen done in other webinars today. So that's why I asked Tom and Fraser to join today. They are our legal counsel, and their approach has always been proactive and not reactive. They really go beyond smart advice for sticky situations and delve more into it, really starting with the client, starting with the team, making risk management a whole team approach. So that's why we chose them. We stick with them. And throughout this presentation, they're going to really hone in on clients, the process. If you have a go no go criteria, looking back on lessons learned, looking forward, really how it all fits together. Today we're going to be covering a lot of ground. And we hope that what you take from this session is just to be curious, to know that there are creative legal solutions out there, to really start from the beginning, even with crucial conversations with your team, with your clients, being able to explain to them or have your attorney hop in and explain why maybe a risk and reward equation doesn't balance for you. It doesn't make sense. To talk about why you can't take on an uninsurable risk. What is an uninsurable risk? Knowing what to look for before you get too far down the road is really what is going to future-proof your firm. So Tom and Fraser, they practice out of Seattle, and Tom, he has extensive experience in construction, design law, contract negotiation. He's been a mediator, working with firms as large as 30,000 people and as little as 2. And Fraser, he specializes in technology, business law, real estate, tax law, primarily in the US. I believe, Fraser, you mentioned that you practiced in Beijing for 12 years, in Taiwan for 5. So pretty crazy, almost 2 decades. So they come to us with over 60 years of combined legal experience. So we're very lucky and fortunate that they're going to be here today for us. And so with that, Tom and Fraser, take it away.
Well, what a gracious introduction. I'm going to interrupt Tom for just a sec. 58 years of combined legal experience.
I was 2 years off, sorry.
Oh my God. See, this kind of misrepresentation is going to get you into deep trouble.
Yeah, there you go.
So just to follow up on what Brittany said, I started out as an electrical contractor back in the 80s, then went to law school and started working for homeowners mostly in first law firm, then ended up at MBBJ as their general counsel. And now I work for mom and pop firms, and I work for fairly large design firms. So it's a broad spectrum.
And I'm a similar vintage as Tom. We actually went to law school together. Both graduated in '94 from University of Washington Law. My background was in technology. I used to be a computer programmer, and then I went to law school and wound up practicing in Asia, in China, and in Taiwan for a long time, representing primarily US companies in China, including at various stages, NBBJ, various other design professional firms that were doing projects in China. And then, when I relocated back to Seattle in 2008, started doing a lot more work for design professional firms. I'm what's called a big law firm refugee, had almost 20 years with large multinational law firms, and then decided to set up my own small firm. A bunch of my clients came with me, but by being in this boutique firm with Tom, I'm able to work with a lot of clients that sort of hadn't been able to continue working with them as a partner at a big law firm. I do a lot of my work is IP dependent. So I do a lot of work with clients, helping them protect and strategize around their most important soft assets, the IP, and whether that is doing stuff with copyright and making sure that they're thinking hard about copyright, about managing the soft assets within the firm, and managing the assets with respect to your clients. So I think that's our short intro.
Yeah, Fraser, I think, contributes also on the business law and employment law sides.
So today, just kind of here's a bit of a roadmap of what Tom and I are going to be talking about. Fundamentally for us, and it's for what we do and what we advise our clients, is that a successful client engagement is going to involve managing expectations out the door, nurturing that relationship, and then making sure that all of these hard, crunchy contract terms are going to work in your favor, or at a minimum, aren't going to put you at a disadvantage when you are into a project, when you're working with your client. So beyond that trifecta of the three most important things, we're going to have a few points to make about quality control, ensuring that project scope stays in its box, and we're going to be talking about project scope multiple times in the course of the next few minutes. Cost control, and just the ongoing management of the relationship.
So you'll see this last item down here is the top 10 contract mistakes, and we're hoping we don't get to that because you're going to be so actively asking us questions that we'll want to answer those questions instead. So you will have the PDF that has it, but it's kind of a top 10 list of David Letterman style.
I love it.
So
the first thing I think that's most important is to understand that everybody's got to succeed in a project for you to succeed. It's not one party gets to win and two parties get to lose, or one party loses. Successful projects just don't get out of balance, right? Everybody's giving and taking. And so contract is one way to help you set the appropriate balance, and with your prime agreement with your owner, that if you are the direct prime, and then by that discussion, working through the types of clauses that you'll want your owner to have in the contract with the contractor. And then if you're not the prime, if you're a sub, then looking at these things just as well, but trying to get the opportunity to coach the people who do have the prime agreement so that they don't set poor expectations in contract. And that way you can help maintain the balance from a coaching perspective rather than a negotiating perspective. And you need to go into it understanding your own goals, but also understanding the client's goals, so that you can manage that balance as the project develops. And so some of those management issues, and I'll speak from an architect's point of view, there are going to be design goals that are going to be created. And then, of course, the whole engineering design team are going to support those design goals. And they're going to be traded off against project cost and time. And so you want to balance those as well as balancing expectations. You want to balance those three as the project develops in order to come to that end of a successful project. And really, the way to get to that end is through active communication. And we'll talk a little bit more about communication as we go down. So the contract is the piece that you start off with first, usually. Actually, that's not true. You start building the relationship. They say, well, we want to work with you guys and give us a proposal. And all of that is kind of fluffy and doesn't get very difficult at all. But then you have the contract that comes along. And what I say about contract is it's really important to use that contract negotiation as a relationship building tool. So going into it with a full understanding of your needs, and then reaffirming the client's needs, recognizing that there's going to be some compromise, but there's also going to be some really a lot of explanation of why do you need this way? Why do they need it their way? And so that you can literally get beyond the we've got to have this indemnity to we need this because. So once you get that because portion, then you can respond with something, well, we can achieve that end through, but we'll use different language. We can achieve that end, but this also achieves our needs. And so that's how you start to build the relationship in contract. Then once you've got that, customer service is critical. And what I think of as customer service is very upfront communication, talking all the time with your customer about what's going on in the project, what you can do, where it's going, where the issues are, where the ad services are. Just keep that moving and taking care of their needs, which you do through the project communications. And then there's always going to be problems. So you try to see ahead as those problems come. So one way of seeing ahead, for instance, is you potential ad services logs, or you see something that might turn into a problem. So you talk to the client early on. That's the proactive piece. And then even handedly is don't always just think about yourself. You've got to think about the balance between you and the client's interests, and have some consideration for what the client's interests are. And of course, that's going to vary with client, because if you get a very selfish client, you may have to be more you're interested and in order to maintain the balance. But if you get a client, more reasonable client, then you can often go in with a solution and not have to worry about negotiating to a less favorable position. Then this last point is it's hard. And so especially now, it's hard to make relationships with people. So making the relationship you have, well, I can give you a great example. Brittany and I know about each other's pets, and Brittany's my client, and I like knowing about her. And we don't have a relationship out of work, but we do have a relationship within work. And so those are difficult, and it's important to maintain those to make a good connection with your client.
So moving on, key contract terms. And like as Tom was saying, the relationship, knowing the relationships outside of work, listening to his beautiful songbird singing in the background. It's one of the highlights of my calls with him. Sorry, Tom. It's, your bird does take precedence.
Oh, he does, yes.
So key contract terms and scope again. And we, as contract lawyers, we are just we focus on mitigating risk. We tend to be negative Nellies at times because we're looking for all the ways that things can go wrong. And probably the biggest one is scope, because poorly defined scope up front it just feeds through the entire project. And so we encounter bad scopes all the time. And it's so we focus on it. And that's where having a clearly defined scope with necessary exclusions foundational, both from the obligations it imposes on you as the design professional, but in setting the expectations of the client up front as to what they are going to be getting. Next, schedule, which is oftentimes just seems so duh. Yes, of course, but you have a really clear idea of what the scheduling is going to be. The clients don't always, and oftentimes they have unrealistic expectations. So you need to be really, really clear on what is that scheduling, and then describing what's going to cost money if there are changes along the way.
And what we frequently see is that folks agree to a construction administration period where they've got a lot to do, and during the construction administration, they agree to one that doesn't have any limits. So if something goes wrong with the project, like anything that goes wrong with the project that delays it, here we are. Now we're spending a lot more of our time on the project site, or we're being made totally inefficient. But yet our contract says we do construction administration, and it's not time limited.
Yeah, And I'd just like to add, Tom, for your suggestion to us years ago, we've actually changed our terms to say, you know, our building envelope related work is going to be 16 months. And if it extends beyond that, then it's going to be X amount per month kind of thing. So that was really helpful that you suggested that.
Yeah, it's critical to your success, I think.
And then setting out what is both the fee, and that fee needs to tie together really tightly with the scope and the schedule, because sometimes when you have a team working on something, working on the proposal, those things might not always align. That becomes critical. And that comes along with, I think an issue of called, the right to stop work if you are not getting paid. And there's problems that, built into, as Tom and I were just chatting about this, and built into the AIA contract. Tom?
Right. So a couple of things that come up for me here is with respect to payment terms. It's just, these are not a problem built into the AIA contract. This particular problem I see comes up often all the time in edits to it, though, is that they make payment subject to no dispute. And the problem with that is it's so easy for a client to say, I have a dispute, even a good faith dispute, right? You've made a mistake. It's not negligent. It's really a minor mistake, but any mistake is sufficient for a client to say, we're not going to pay you.
Hey,
And then if you don't have the right to stop work to challenge that, then you're stuck working for this client and not getting paid. And so these payment terms end up being related to the right to stop work. Those are pretty critical and joined.
And if anybody's not on mute, I think we're hearing some background noise.
Yeah, almost sounds like a potato chip bag.
Yeah.
Okay. And then, the last point here is risk allocation is just ensuring that there is a discussion up front. It's in the contract, who is bearing the risk, because at the end of the day, your client is going to want you to bear all the risk, which is not reasonable or fair. And so there needs to be that discussion up front, and you need to pay attention to that allocation of risk in the contract.
Right. As Brittany said, this is the risk reward ratio that she was discussing. And when she opened this meeting, is how do you balance risk with reward? And there's the limitation of liability, and there's also waivers of consequential damages. And we'll talk about those more in a little more detail. But I want to talk about a little more subtle contract terms. Standard of care. You don't really have to have a standard of care in your contract as a design professional, but because it's more philosophical, legally, it's always implied, just like it is, you don't sign a contract with the doctor or with the lawyer. The standard of care is there. They're professionals too, and they also have a standard of care. But I find in architecture and engineering, it's really important to have a written standard of care so that your client understands that this is a human endeavor, and you're gonna screw up, you're gonna make mistakes, and that doesn't make you negligent. Just because, even if you make a boneheaded mistake, and I've seen a couple of those, that does not make you negligent. And then the waiver of consequential damages, I couple that with the limitation of liability, because what a waiver of consequential damages does, it limits your liability for stuff you can't measure. So the easiest example I have, if you're working on a venue and the venue is supposed to open September 1st for its first show, and you don't have the project doesn't finish on August 28th when it needed to finish, then those consequential damages are all that lost revenue from the September 1st show, but those may not be your fault. So, and likely are not your fault, right? Or it's a mixed fault. And so you really need to understand, either get those types of damages waived, or understand what can cause them so you can make a risk reward balance. And then making sure you set expectations, right? Clients need to make decisions. Consultants need to get their stuff in on time. So you need to look at the contract or look at the project as holistically and say, what do I need from what people at what time, and make sure that gets communicated to them.
And then what are some of the mistakes to avoid? And top of the list again, so we're kind of repetitive this way. An ill-defined scope of services. For example, any unlimited services, as Tom talked about, construction administration is one of the perennial problems that pops up, and it can be it can make or break your project. In some cases, it might make or break your company. And then value engineering, which is particularly constraining, something like value engineering in the context of the scheduling, because you might agree to the value engineering, which would make sense at the design phase, but once you've gone to construction drawings and you need to revise, then suddenly that can totally crater a budget.
So, and we often see projects where owners are driving pennies out of the project at the end of construction documents. And so they'll make stupid changes because they're kind of free. If you haven't value engineering responsibility, they can make you run around in circles, and you can spend $5 to save them 50 cents. So it's important to get that clear.
Tom, it sounds like you might have some kind of some scratchiness with your mic or something.
Yeah, I was wondering maybe, Tom, it might be coming from your end.
Okay, well, that's too bad because I have no clue what to do.
I'm looking at all the attendees and it looks like everybody's on mute. So it's got to be from one of us.
Well, let me mute and unmute, and Fraser can go forward, and I'll just mute and unmute as I can. I don't know what else to do with my mic.
Well, it actually, this last little bit of you speaking sounded fine.
Yeah.
So next point here, just to, sometimes people focus on the contract, focus on a project, and they look at the contract as kind of this isolated unit, but they lose sight of the relationship. And the contract is a building block in your relationship with your client. And so you need to think of, so not only are the contract terms important, but looking at it as a piece of of maintaining and nurturing that relationship with your client. The third one, and underlined here, you don't follow the contract provisions for obtaining authorization for additional services, because sometimes that's like, well, of course that, we've got into the stage of design and it makes absolute sense that, the client, project manager is saying, yeah, we need to do X. And you say, well, we've got into this point. Yeah, it needs to be done. And your people do it because it makes absolute sense to do it. But the contract says, the project manager, the client's project manager doesn't have the authorization. You have to go through a procedure for getting that authorization for additional services. And the client doesn't agree. They don't say, well, we didn't actually authorize that. And so you just did that work for free. Now you have an argument over, are those additional services payable? And so sometimes it can seem nitpicky, but you need to drive that process of following the contract provisions for ads.
Sometimes you're going to have to remind your client that they drafted that into their contract. This painful process that they drafted into their contract, but you're going to follow it because they thought it was important at the time, and so you need to follow it now, or you can change the contract if they want to do a different process.
And again, this is the communication and managing the expectations, particularly if a client gets grumpy about the slowdown that going through an authorization process creates on the project. But they required it up front, you agreed to it, and if you don't follow it, then they don't have to pay, which bad result for you. And then taking, the design professionals oftentimes can take too much responsibility for the budget on a project. And ultimately, you want to have as little responsibility for that budget as absolutely possible.
What I see often, well, let me make a quick point about the contract provision for obtaining authorization for additional services. If back in the relationship building stage, this is a good time to discuss that, whatever requirements are, so that, for instance, I often see you have to have a written ASR. And so I suggest to people that we should put in the contract that can be done by email, so it can be quick. So you can have the opportunity to quickly authorize us in writing by email to do those ad services. And that's almost always received well. So back to this taking too much responsibility for budget. It's unfortunate, but the AIA contract has you being responsible for budget all the way through the end of construction documents. You do your CDs, and then it goes out to bid, and you're supposed to have a crystal ball. And in this world, with the supply chain disruptions and what's going on with escalation in contracts, this is a crazy time. But it was never sane to take on that responsibility. So what I see most people accepting and most design professionals doing is cutting off that responsibility at the end of SD, schematic design, or DD, design development, so that you no longer have a budget responsibility, except that you have to follow the design you provided. So if you provide SD design and your responsibility for a cost ends at the end of SD, and you make changes to SD during DD that meet the needs of the budget, then you're off the hook. But you can't then go around and change the scope of the project, of course. You're going to be on the hook for that. So it's not like it's a license to kill. It's just you're not responsible if you follow the direction that you've led the design down. Then the owner has to figure out some other way to manage costs, not manage it on the backs of the design professional.
And then after talking about all of these, things to avoid, what happens if you do have a contract that has bad contract terms? You have poorly defined scope that leaves you on the hook for more than you expected, but the client is expecting something more. Consequential damages, standard of care, client responsibility. Oftentimes, contractually, mitigating these is really difficult. The first stop is always going to be depending on going to the relationship you have with your client, is maintaining that open communication, making sure you have the contract is one piece of the relationship, but it is not the entire relationship. Because if you have something bad in the contract, you can soften the impact by having good communications with the client. It's not a perfect solution. It's better to have a perfect contract and a perfect relationship. But a bad contract and a good relationship is much, much better than a bad contract and
frankly, better than a good contract and a bad relationship.
Yes.
There is something you can do specifically to mitigate against consequential damages. And we'll talk about this later in the show as well. But there's one of the things you can do is make sure you document what's going on. So how consequential damages occur is because there's been a project delay. And often at the time when the project delay happens, then that's the time for you to annotate that this is what this delay has happened in the project, and this is what the cost is. Because as Fraser and I were discussing, these contracts take 3-4 years sometimes. And so you may not remember 2 years down the road what caused that delay. But if you have a contemporaneous documentation of what caused the delay, then you can avoid having that land on your shoulders unfairly. So the next stage is getting your internal quality control act together. And so obviously the most important thing is have the right team for the project. And we all do a little stretching in our businesses. We all take on stuff that is maybe that we don't have the perfect team for, or it's a stretch for any particular team member. It's important not to go too far. And if you have that situation, it's important to support that team with some supervisory help. So, but the key is get the right team for the project, so that you don't, so that you aren't delivering the client a project that ultimately they paid for the right team. They didn't pay for inexperienced people. I think it's important. Excuse me. I think it's important that the I apologize, this cold is hanging on, that the project team understands the scope, specifically the ad services line, because you need, projects are going fast. Responsibility is delegated. So if you don't have the project team understanding what's in scope and out of scope, there's often, it's easy to do stuff that's out of scope without having known you've crossed the line. And then you do what CC Hall told me that you should never do, and that you spend other people's money without their permission. And they typically don't want to pay you when you do that. You should have internal protocols and make sure your deliverables go out. I mean, for instance, Fraser and I, what we like to do is we like to be editors for each other. Look at an important letter that's going out to a client and making sure that it's got another set of eyes. Make sure the staff knows what happens when there's a problem. I've seen in some of the larger firms where, people stuck their head in the sand because, oh, there's a problem. I don't want my boss to know. I'll just keep quiet. Maybe it'll go away on its own. Bad decision, right? Problems rarely go away on their own. And even if they would, it's better if the people who should be escalated to the senior staff understand what's going on and they don't get blindsided. And then make sure that you've got the right supervision to go with the stamping requirements. I see all the time firms who, for instance, they'll have a Texas architect, and they'll have a project in Texas, but the Texas architect isn't involved in the project at all. I worked on one project where the project architect, or the person who stamped the drawings, I should say, spent 1 hour on the project. And so when a problem occurred on that project, one of the things they claimed was that it was negligence for having the person who was stamping the drawings only spend 1 hour on the project. That it's in and of itself was negligence, independent of what went on the drawing. So it is important that the people with the licensing do spend the time on the project to make sure it meets with the requirements of the jurisdiction. Oh yeah.
Our favorite worm here, the scope creep.
That is so awesome.
So
I blame all the cartoons on Tom. He's the one who dug them.
I see Tom written all over that for sure.
So as Fraser said, we've hammered so hard on scope, and it's because that's where we've seen the most problems. And so it's such a straightforward thing. I mean, we can't write your scopes for you. Even if we could, it wouldn't be a good thing for us to do. But it is important for, and what we do is when we review contracts, we look for scope that is unlimited. This is a little bit different in its generation. This is talking about adhering to your scope because of the risks you incur if you don't. And so attending out of scope meetings, impromptu solutions, being on site when it's not necessary for you to be on site, advising on means, methods, and safety, and warning the client when the client requires additional services before performing them. Well, we've talked about that and the why. Those first four, however, they led to a problem for a particular client where they did exactly that. They were attended an out of scope meeting. They offered an impromptu solution for the client for in that meeting that they got drawn into. And what happened was the client took the impromptu solution, actually ignored it, did something else, but said they thought they understood that was the solution that the engineer had directed. Then when that solution failed, it wasn't the engineer's solution, but when that solution failed, it ended up killing a couple of people. And then when it killed those people, the engineer was sued because the engineer didn't document the solution and therefore allowed the client to make a stupid mistake of doing the wrong thing, which led to the deaths of 2 people. So look, you're not going to likely run into that. Most of you probably aren't doing sewage plant design, but it's just to tell you the extreme is you can get yourself in trouble by doing things ad hoc. So stick with the program.
Tom always has such cheerful anecdotes and war stories. Cost management. Let's get to something boring. Failure to manage the project budget and your billings is kind of the best way to not get paid for all the work that you're doing and to set yourself up for litigation. Design professionals, any type of professionals really, are really bad at sending bills out because we don't like to do it. You don't like to do it. It's not one of the top 3 fun things that people want to do on Friday afternoon. But if it slips away and you don't get those invoices out, the client doesn't pay, and it can slip and slip and slip, and then suddenly there's this really big outstanding that wouldn't have been too much of an issue on a monthly basis, but 6 months down the line, and you've let the collections get larger and larger, then it becomes a much bigger problem to solve. And you suddenly wind up having to throw a whole lot more management time, a whole lot more of your time into dealing with a collection of a big outstanding AR, as opposed to just doing that monthly chasing of a slow pay. And once you have a big outstanding AR, sometimes the only recourse is litigation, and litigation is always the worst case solution.
Yeah, a couple of added points on that is that if you are chasing the receivables monthly, then you see the red flag pop up. But if you let it sit for 4 or 5 months, then by that time the flag is burning. And the other thing is, if you do end up in a situation where you want to sue for your fee, you can almost count on getting a countersuit in negligence, because you've made a mistake, and anybody can say that that mistake is a negligent mistake. Even if it's a minor one, they can call it negligent. So it just ends up being a compromise. But if you keep on top of it, you can either see that red flag, or you just get your money and you avoid the headaches.
Love that you brought that up. We don't run into this, but long before I was with the firm, sometimes they would wait a while, or so, wait until it was down the road and try to bill when design was done and they're in construction. They would reject it and say, look, that phase is done, that money's gone, we're now in a different phase. So just billing in that stage of the project is important.
That's so funny. I'm working with a client right now who did not chase billings, and they're $100K in the outstanding receivable, and the client's not paying any of it. So I'm having to get involved to help them try to collect that $100,000. And had they stayed on top of their billings, we wouldn't be in this place. They could have stopped work months before they ran this huge bill up. So one of the things that people often do, or don't do, I should say, is they don't do things that make sense because they take time. So they don't spend enough time planning because it takes too much time to plan. Let's just jump into design. They don't spend the time to do a kickoff meeting internally because, we're a team. We work together all the time. We don't need to kick this off. And I disagree. I think kickoff meetings are really important, both internally and externally. This one here, talking about the scope again with your team. You often do things in patterns and processes, and sometimes your client's going to want you to vary that. And so it's important, if there are special clauses in the contract that vary the process you would normally do, you educate everybody. We've got a varied process on this. We're going to be doing it differently this time. And then everybody understands what the limits of responsibility are. What does it say in the contract, and what do we need to do, and make sure that those two all coalesce. So really it's discussing anything that's different from the norm, and then confirming if it's all completely the norm, confirming that. And then if there's any special risk issues in the project, schedule is often a special risk issue. I see it almost in all contracts as a special risk issue because almost everybody is, it's the time is money, construction, a month late. I was just discussing with a big general contractor, a month delay in construction. What's that cost? $100 million project? Is that $100 million project? Is that $1 million a month? It could be. It could be more. It could be $2 or $3 million a month. I was just talking to another architect. Project delay. They're expecting the project delay to cost 20%. It's a 6-month delay, so it can be huge. And then there's the client hot buttons. And that's something, hopefully you've had this negotiation with the client and you've understood what really is of concern for them. And maybe that's communication about ad services, or maybe that's design changes, or whatever it may be. Hopefully you've learned in your communication, building your relationship with them, what's really important to them. And you want your team to be educated to that, because that way it doesn't slip by. And then there's the outside, external kickoff meetings. So you do all this project work, you create this great contract, but now you're bringing a third party in who wasn't around for that building relationship, wasn't around for understanding what that scope is, so you want to make sure that that party gets educated as to what the expectations are, and then you review the things that are critical for a project to function well. As remember, we first said project success is based on balance and everyone succeeding. So the way you make everyone succeed is making sure you communicate well. Communication protocols is the top item there. And then you can talk about sequencing, because oftentimes you don't know anything about sequencing, but you need to know more because you support construction and responding to RFI and submittals. Then there's the local laws or regulations that may impact the job, contract clauses that vary the normal behavior, and those happen all the time, right? That you get into your process, and those may impact the builder as well, or the owner, and then any other unusual elements. So these project kickoff meetings are a good place to really just get everybody starting from the same place.
And I just want to let you guys know we're about 12:43, just on time, about a little over 15, and anybody who wants to stay on longer can.
Okay, well, what perfect timing, Brittany, because the one thing that Tom and I want you to take away from everything we've said today, and we've covered a variety of different things, maybe not in as tight and concise a format as would be ideal, but in terms of project communications, the one thing we want you to take away is any risk that you've communicated belongs to the owner, belongs to your client. Anything that you haven't communicated, any risk that you haven't communicated, that belongs to you.
And so this could be as simple as I had a job where they changed the sealant between the top of the sheet, in a commercial job, between the top of a sheetrock and the ceiling. And the design professionals didn't know anything about that sealant. So they said, yeah, well, let's go ahead and use that sealant. But they did communicate to the owner, we don't know about this. This may crack, this may do this. This is good. It seems like a good solution. The manufacturer says it's a good solution. You just want you to know we haven't used it before. And so then if it fails, it's not on the architect, right? Because they've communicated the risk. probably a bigger thing was this hospital job was going on in Southern California. And they wanted a particular type of framing structure because it would lead to more accelerated construction. It's called moment frame for those of you who are into structural engineering. And so moment frames had been approved by the Northern California version of the regulator, OSHPD, but the Southern California version of the regulator, OSHPD, had not yet approved it. So, but the design team thinking, well, if NorCal OSHPD says it's okay, SoCal OSHPD's going to say it's okay. They went forward with what was an owner request, right? They didn't communicate. This hasn't been approved in Southern California yet. And if it doesn't get approved, it's really going to screw up our project. Well, you can guess why I'm using this example is that SoCal did not approve it. It led to redesign after construction documents were complete because of the extreme pressure to get the project started and because it was going to take longer because it wasn't moment frame. The design team raced to redesign the project. And as a result, there were tons of errors. And this job ended up being a huge litigation mess when it was over with. So that was just a simple email to the owner. Well, they had these discussions. This risk was communicated to the owner. They just didn't put it in writing. So then the owner said, we didn't know. So you don't put a communication in writing. You may as well have not done it from a legal perspective. You know, you get an honest person, they're going to agree. And if they remember, they're going to agree. But even honest people forget. So documentation is really critical.
Which takes us to project communications.
So the one thing I see often with project communications is they kind of try to solve their problem rather than being solution oriented. So if there is an issue and you need to communicate it, make sure you're solution oriented within the scope, but solution oriented. And you utilize communications to promote clarity. That's like the communication of a risk. It's just there to promote clarity. Here's the risk out there, and we can't guarantee you won't get it. And then often I see people, I can't tell you how many times I've seen this. There's so the owner's done something the architect doesn't like. So they write this letter and say, we didn't like this and we expect you to sign on the letter. That's not a real way to engage your client. So yes, you do need to have a written communication, but don't be harsh in that communication. You can be firm. If they're doing something crazy, you can be firm and say, look, we just need you to understand that we're not taking responsibility for this, but do it in a way that is gentle but firm, and it's not confrontational, because in order for it to be effective legally, it does not need to be confrontational. It just needs to be communicated. So make sure you keep your communication not confrontational.
And then project documentation, which is the third note of this that we keep on repeating is the documentation. So it's one thing to tell the team members, document everything, but your company needs to have a document retention policy. It needs to be communicated, and people need to be educated about it, and then you need to follow it for both in terms of managing your relationship with the client, managing the communication so that you have that history, so that particularly on projects that evolve over time or last a long time, that new members coming onto the project a year or 2 years down the line have that memory of that written documentation of what occurred previously, and you are able to have an intelligent discussion with the client when they misremember something, or their memory is not what you thought they had wanted. Document everything. Email is great as long as you've taken measures to file it and preserve it. And the last one, which just applies to almost everything, is really hard to follow is don't put anything in writing that you don't want to see made public, that you wouldn't want to have someone read it out loud in front of a jury.
That simple rule is really helpful. I tell you, I have read so many email that just didn't make sense. I think we have to actually stop.
Okay, Tom, there's a couple of questions. I'll let you.
Stop here.
We're getting a little bit of choppiness on your video, Tom.
Yeah, I saw that maybe my internet connection wasn't working, but seems to be working now. So, Brittany, it's over to you and questions.
Well, thank you. You guys did amazing. And for anybody who doesn't see in the chat box, I put the PowerPoint in there. We didn't get to the top 10 contract mistakes, but maybe if there's room after any questions, we can hop back to that. So it looks like there's a couple questions or 2 questions, Tom and Fraser, in the chat box. Sarah Davis says, we usually structure fees by phase amounts and end up going over budget and then not getting paid. So is it better to raise fees or structure contracts differently?
So I think the structuring fees by phase tends to work against the design professional because it wants to be a guideline to the design professional, but having it be a contract provision ends up meaning that it can be used against the design professional if they run over at the beginning of design. But there's nothing that really helps you. You can use it, structural fees by phase, as a tool to tell you how fast you're spending money. And oftentimes, if there are 2 reasons why you don't have enough fee. One, you didn't have enough fee to begin with, and so you're not going to be able to fix that until you get to the next project. And 2, you spend some time on distractions or tangents that don't serve your project necessarily, which really would be something you might want to discuss with the client. Should we race down this rat hole and check and see what's going on there? There's something called set-based design that's really applicable here, and that is, if you want to look at some options, it's often better to spend more time up front looking at all of the options at the same time, carrying them forward, and then picking one later on, so that you don't have to go back and redesign your project because you've selected an option that impacts the rest of the design. So it gives you more intelligence in what fits there. But I think the answer to this question, it's not segregating your fee by phase, except in that one little client problem. It's not having the right amount of fee or spending fee when it's unnecessary to spend it.
Perfect response. There's another question in the chat box. It says, when we write contracts to our consultants, we include a sentence like, consultant shall be bound to us in the same manner as we are to the client. What would be the benefits of this practice?
You want that one, Fraser?
I'll let you take that one, Tom.
Okay. So it's really a very common practice. I see it I represent a lot of consultants, and I see it in their contracts from their prime design professional. It is not, it can be problematic for the consultant, but the benefits to the person who's writing that in the contract is the key benefit that I want to see when I'm representing architects who are hiring consultants. Is it makes the consultant have to look at the contract between the architect and the owner, to understand what their scope is. So that's really critical with mechanical engineering, electrical engineering, structural, so that those engineers recognize that they own their own scope. And oftentimes, if you have a contract that defines the mechanical engineering scope, they may miss something the prime agreement requires. And what you're saying to them is, no, we're not going to go to the scope that you wrote in your proposal. You have to read the prime agreement and make sure the scope in your proposal covers the prime agreement. And if it doesn't, you're the one that's on the hook. We're not going to pay you ad services to meet the prime agreement. That's the key thing. And so I don't see that as being necessary when you're hiring consultants whose scope is limited. So a specifier or those types of folks where there is limited scope, but this, people who have the same similar scopes you do, just a different design area, then yeah, this is a very beneficial phrase. I sometimes write it more than one sentence, but this sentence will do.
Point. So if nobody else has any questions, I thought, Tom, it might be helpful, or Fraser, Tom, you do it so well when you talk about prevailing attorney fees and uninsurable risks. So I thought maybe that'd be a good one to bring up while we've got everybody.
Right. So there are, gosh, there are these key uninsurable risks that occur in so many contracts. The prevailing parties to attorney's fees, inappropriate indemnities. Those are the two typical uninsurable risks we see. So what I mean by an uninsurable risk is if for some reason you have to pay that penalty, your insurance company won't cover it. And or if it's not a penalty, sometimes it is you're required to do something that your insurance company won't do for you in a claim situation. So those two things that are coming up. What I say to often to clients, and mostly, the larger corporate clients, they know it's a business decision to take on this exposure to uninsurable risk, and they often choose to do it because it's a multi-million-dollar job. But if you're a smaller firm and it's not a multi-million-dollar job, one of the things you can say is, we just can't take on uninsurable risk because it puts our company at risk. We're a small company, and uninsurable risk is more risk than we can bear. So you need we need to tailor our contract towards that risk that's insurable. And the reason prevailing parties attorney's fees are not insurable is because your insurance policy, your professional liability insurance policy, says directly in it, you can't take on risk in contract that you wouldn't have outside of contract. So if you take on an attorney's fees clause in Texas, well, you're not taking on risk that's not not outside of contract, because they have a fee shifting arrangement in Texas for design professionals. So it wouldn't matter there. But if you're in Washington and you take on the prevailing party's attorney's fees, that's something that isn't put in there by state law. And therefore, you're not responsible for them unless you agree in contract, and it makes them uninsurable. Indemnity is the other big thing. Really protected in Washington and California on indemnity, on the basic rules. Oregon has some protection as well, but many states do not. And you are only able to indemnify your client for their damages to the extent those damages were caused by your negligence. So if you have any broader indemnity than that, it's not an insurable indemnity. Now, what happens in Washington and California, and to some degree in Oregon, is the state law edits those. And it says, you can agree to this indemnity that's horrible, but we in state law, we're saying this is the extent of the indemnity period that can be enforced. The really big issue with that is that the laws are not written perfectly clearly. So even if you accept a bad indemnity in Washington, there may be some consequences, or California, there may be some consequences, but they're rare. And it's just you have to do it on a case-by-case basis. How do you feel about this client? What's the relationship? How important are they? Those types of things.
Amazing. I know that's a lot. So does anybody have any questions on those two? I have one more topic I think people wanted to chat about. Looks like we're good. So Tom, another topic that came up during our planning for this was they wanted to touch a little bit on electronic signatures. I know there's a lot of DocuSign out there and just other ways to sign contracts. So how do you feel about electronic signatures being legally binding? Are there any kind of risks we should be aware of? What are your thoughts about that?
The Fraser is competent to respond to that.
He looks like he wants to.
Well, not that I want to. I just drop the share, and now we can just have the gallery and chat. Electronic signatures, if you use something like DocuSign, you use one of the electronic document signature providers that works. Putting, signing a document, scanning it, and sending it, more challenging. Copying and pasting your signature into a document probably is not enforceable in most places, would not constitute a real signature. But I believe all 50 states, so here in the United States, all 50 states have adopted an e-signature law that's based on a model law. So and what that requires is that there be a provider that is maintaining a log of people logging in, when they have checked the box, when they have, so it's essentially checking all of the boxes. Do we have some evidence that a computer at a particular IP address, and someone saying that it is Brittany, is signing this and is making that that affirmation on behalf of a company, and you've checked all of those boxes, and you have that record, and you can go back afterwards and see that it was on Thursday, April 21st at 1:02 p.m. that Brittany checked these boxes and affixed her electronic signature. And then that record of it is not in your hands. It is in a third party's hands. So if you're following just kind of, you're paying the price for that e-signature provider to provide all of that background services, then electronic signatures, those work. But doing a cutting and pasting your, signing your name and then taking a picture of it and then dropping it on a document is not 100% foolproof. It is not the equivalent of a wet ink signature where you have actually physically signed a document and then scanned that document. And then just, in the international context, almost all major countries have adopted e-signature laws, which is important and useful, but do not be lulled into complacency with, the fact that, for example, China, which has a wonderful and a very progressive e-signature law, but in reality, a lot of stuff needs to be signed physically.
That's perfect. Yeah, I know a lot of people were curious about that, so that's super helpful. It's kind of like an audit log in a way, right?
Correct.
Got it. Well, does anybody else have any questions? I know we're running a couple minutes over. We've got a thank you in the chat. Thank you, Tom and Fraser. You guys killed it. Appreciate your time. More thank yous.
And yeah, if you have any more questions, feel free to call Tom. Feel free to call either of us. We are here in Seattle, and in the presentation is our phone numbers and our emails, and this is what we do. We love talking about this stuff.
I just want to second that. Really enjoy having spent time with you, and hopefully it was helpful for you.
Everybody in the chat box is loving you guys. So thank you guys so much for your time today, seriously. And for everybody else, we will have the recording. And if you didn't get the PDF, I will also make sure it gets emailed out to you within 48 hours. There'll be a feedback form sent as well. And then we've got a couple programs coming up in May. So we've got a roundtable on May 5th on social media. And then we have on the 19th, another one on safety consultants. And then a week after that, we have a stylist. So we have a lot of fun ones coming up. So hope to see you there, and happy Thursday. Bye, guys.